Well, good afternoon, everybody. We've got a big turnout today, which tells me that everyone is really interested in this topic of thinking through the issues that we're all figuring out related to Public Act 102-702, whereas we've more appropriately or been calling it the Trailer Bill to Faiths Law, and what that means for us. So we appreciate everybody joining us today. For those of you who don't know us, my name is Brandon Wright. I'm joined today by my colleagues David Braun and Ellen Lueking, who are going to talk to us about all sorts of the issues that we're all facing and thinking about together as we work towards the implementation of the Faiths Law Trailer Bill. So as we work through our afternoon together, please feel free to ask questions through the Q&A feature. We're going to be monitoring that. You've got the ability to upvote questions. So if there's one you want to make sure that we answer that you see there in the queue, please make sure that you do that. But I think our plan is we're going to try and briefly hit some of the key points that we think you are going to ask about, and some of the key pieces that are important as it relates to the statute. And then from there, we'll jump into spending the majority of our time answering questions and having discussion about that. But I think our plan is to handle it that way. Anything before we jump in, David or Ellen, that you want to kick us off with as we start?
No, I think we're good to go. Let's get going.
All right. Well, let's start by just reminding ourselves some things that are in the statute, and then we can get to the questions. And of course, please ask away at your questions. Before we get to 102-702, we have to go back to a slightly earlier public act, which was the original Faiths Law, Public Act 102-696, that created some of the definitions that are important for us as we think through the issues with the trailer bill and new statute and what that means for us. And most importantly, is that definition of sexual misconduct. So as we are talking about what we're required to report and ask about and deal with through our employment history reviews and our disclosures for applicants and all of that piece, what we're really focusing on is sexual misconduct as it was defined in the original Faiths Law. And as you see here, that means any act, verbal, nonverbal, written, electronic, or physical, between an employer, agent of the school, and a student that is, aimed at establishing a romantic or sexual relationship, and that includes, but is not limited to, sexual romantic invitation, dating or soliciting a date, engaging in sexualized or romantic dialogue, making sexually suggestive comments that are directed towards or with a student, self-disclosure, physical exposure, or other inappropriate, sexual, indecent, romantic, or erotic contact with a student. So this is an important foundational piece for us. When we're talking about sexual misconduct, we are talking about this definition of sexual misconduct. So I want to make sure that we all understand that that is what we're talking about as we walk through these items today.
And I think that one thing that's worth noting too, first of all, I want to point out again, Brandon said it 3 times, and I want to say it one more, with a student, because we're going to have Title IX obligations as well, and those may include staff-on-staff misconduct. But this law really deals with reporting obligations that have to do with when there's such an interaction, a qualifying interaction between an employee and a student. I think there's a secondary piece that I want to make note of here, because we're going to discuss a lot about sexual misconduct, but where this all started was, or at least where some of this started, was a particular gap in the statute with regard to grooming. And one of the things that we tend to do a lot of times, that I tend to do, I won't speak for anyone else, is I tend to mix up that definition between sexual misconduct and grooming as though they're one thing. And I think it's going to be important for purposes of analyzing what we're doing going forward to recognize that sexual misconduct is in many ways broader than the definition of grooming. And the definition of grooming, as we think about it, sometimes we use that term a little more liberally than it is in the statute. The definition of grooming in the statute, which used to only include electronic conduct and has been broadened to include other conduct, now still requires an attempt for sex. It requires luring for sex or an attempt to procure sex or sex itself, those kinds of things. The definition of grooming does not include fostering sort of a generalized personal relationship with a child, which is what we think of as grooming, which may be sexual misconduct for purposes of the definition, but not meet the legal definition of the crime of grooming.
And I think one other thing, and Ellen, I'll ask you this. I mean, when I look at this definition, I definitely see an overlap between our obligations, not only under Faith's law, but clearly under Title IX as well. And, you know, I think we're talking about some overlapping obligations there.
Yeah, I think oftentimes when you're going to have this Faith's law obligation, the Title IX coordinator should certainly be involved and maybe sort of the point person running things on Faith's law as well. But you should certainly be looking for your obligations under Title IX, as well as your obligations as mandatory reporters to DCFS and to law enforcement.
And that, of course, takes us to some of the other, implementation requirements to the original Faith's law. Did see a question. You got the PowerPoint. The link to the PowerPoint is posted in the chat, so you all should have access to that. But Faith's law required us to do a few other things, right? Obviously, as Ellen mentioned, the obligations here to potentially follow Title IX or your mandated reporter obligations to DCFS, that we've got to have employee training related to these issues, that we have to have our code of conduct for employees that talks about that professional relationship and those staff-student boundaries. And I would just remind everyone that the requirement to have that employee code of conduct in place, posted on your website and in all your handbooks, has been in effect for this entire school year, since last July 1 with the original Faith's law. And I still see many handbooks or many websites where I can't go and point to that employee code of conduct that's required to be there. So, just again, a quick reminder of some of those original Faith's law requirements that hopefully we all know and understand and are already doing, because these things already went into effect last year, but I recognize that might still be news to some of us.
And I think it's important on that one that some of those have some blanks to fill in. That transporting a student, taking or possessing a photo or video of the student, meeting with the student, or contacting outside the employee's agent or professional role. If we're not considering the way that, one of the things that I've been advising a whole bunch of is to make sure that when you're considering those policies, one of the things that you're considering is what is an approved method of interacting with, what is an approved method of interacting with students? A lot of school districts have pretty blasé processes for these things. A lot of school districts have processes that that allow teachers to text students all the time on their personal devices, or coaches or other things. If you're not using like a centralized app of some sort and identifying what that app is in your policy that you have full access to and you can track, then you're giving up one of your best arguments in the event something like this happens, which is you weren't using the Remind app. It is by definition in our policy, or the Class Dojo app or whatever, it's by definition in our policy a personal communication.
Mm-hmm. And I think Brandon, there's a press administrative procedure that districts should probably look to as they're creating what those boundaries are. I don't have the citation on the top of my head.
Yeah, and I think that with that press procedure, I've seen, there's sort of a disclaimer at the top of it that says, this is a starting point for local conversations. And I've seen districts sort of take a wide range approach to what they're putting in that policy for those staff-student interactions. Some simply saying it's forbidden always, that an employee should in no circumstances transport a student or take or possess a photo or video of a student or meet with them outside of their professional role. My concern is, I don't know that that's enforceable. I think this may require some nuance. I mean, the liability part of me says that's great, but if we're not enforcing that policy and something happens, I'm concerned about an unenforceable policy. So, I want to make sure that we are, I would take a look at that press example, and it's I think it's attached to 5120. It's actually not in a policy, it's actually in an administrative procedure attached to 5120. And I think that's also why some people have missed it, is because it is on the it's in an administrative procedure created by press and not the policy itself.
Yeah, I think it's really imperative that when if we are not making use of those administrative procedures with press, we are leaving a lot on the table in terms of things that we're actually going to be able to enforce. And I want to echo something Brandon said. There's a great Supreme Court case from several years ago, maybe 10 years ago, dealing with a situation where the employer didn't enforce its policy on personal use of cell phones. The Supreme Court said, no, the policy trumps. But there are two things to note there. One, this is really the first time the district had ever had to use its policy. And two, it took going all the way through the appellate court, where the district was losing again and again and again before they finally got to the Supreme Court. I've seen a whole bunch of writing recently about, well, but if you're not just have the hardest policy possible, the toughest line possible, and that'll be fine because there's this case. And I want to distinguish that while the case is a really good case and it's wonderful for our practice, the facts of that case are pretty unique, where the employer had simply never used a policy that was fairly new. And the Supreme Court said that was not an implicit waiver. But I think a different fact pattern would give you a different result, particularly where you openly allow people to violate the policy by allowing them to transport students on a regular basis when necessary.
Before we move on to the real topic of the day of the trailer bill, there is a follow-up question here in the queue on the web posting piece that I do want to answer while we're on it, which is, the question is, our employee handbook and rules are on a staff-only website that's password protected. Is that required to be on a site that can be accessed by the public? Your face law conduct policy is required to be on a site that is accessed by the public. Maybe not necessarily your entire employee handbook, although it's a public record that's going to be subject to FOIA anyway. So I don't know that there's really any, reason that it shouldn't be on the public website. And I think most districts do put it publicly, but your face law employee code of conduct is required to be accessible to the public on your website.
And I want to add a practical litigation piece for why you keep that on your public website. One of the arguments I've had several times, both in employee litigation as well as with student litigation, is, but nobody knew what the rules were because they weren't easily accessible. And where attorneys are getting this argument is they're literally going to your website to see what's there. And if they don't see it, they have a prima facie case for their complaint. It then becomes upon us to defend you to, no, it was there, it's just you couldn't see it. So it might reduce, I know this sounds crazy, but it might actually reduce the number of complaints that even get filed simply by putting it on your website and making it accessible. It also prevents it. The funny thing about the web is it retains everything. It might reduce the number of complaints that are out there for faulty information, which somebody searched and found in sort of a back website that's still there. I don't know how many districts I have that have both their current website and an old version that are both accessible when you look up the policy of the school district.
So let's get to what we're all really here for today. And thanks for your time on this beautiful spring day to think through this with us. And that is 102702 and the additional requirements that are in place that go into effect July 1st, 2023 this year. So the main points here are there are some notification requirements, parental notification requirements whenever there is allegations of sexual misconduct by a school employee or a school contractor. We're going to talk about that requirement in a little bit. It does require this process for all applicants of employments for the school district or for our contractors. who work directly with children to affirm that they have not previously engaged in sexual misconduct against a minor. And then there is a process here for us to have to go through that employment history review where they are consenting to us to go and seek this information and provide it. And I suspect that that's where most of your questions reside today. So, let's jump into the specifics of that. Unless either of you have comments here on this introductory piece, let's jump in and think about that piece first. And so it creates a new section 22-94 of the school code. That for all temporary and permanent positions for an employment with a school district or with a contractor of a school district, which involve direct contact with children or students, we have to go through this employment history review process. And that's what we have to walk through. Of course, direct contact with children or students is defined as the possibility of care, supervision, guidance, or control of children or students, or routine interaction with them, which is very broadly defined, which will basically carry out almost every person we hire, and for most of our third-party contractors as well, who are going to be on site. And we have to go through that to make sure that there is no knowledge that would disqualify them from employment. Now, we're going to talk about what really disqualifies one from employment, but of course, we're going to have to make some decisions about that. So this is the process that we're going to walk through some of the nuances of. So any thoughts here on some of these initial definitional pieces, David or Ellen?
So go ahead, Ellen.
No, you go.
So I think there's going to be a lot of this is one of those sections where it's so broad and so vague, it's hard to know what it really means. One thing that I want to note out front is we're talking about employment here, hiring here, which is going to potentially distinguish us from volunteers. But I want to watch out for what I think is a trap argument. In a lot of this, those who heard me in Southern Illinois today or last week heard me say a whole bunch that I have become a much less black and white lawyer and much more shades of gray lawyer, because I've seen all kinds of places where I thought the statute was pretty black and white. And then once we get into the facts, things start to look a little gray. One of the things I want to watch out for here is that while I've heard a whole bunch of hay made over what constitutes a hiring and whether we're paying the person or whether whether they're volunteering their time and all kinds of other things, I'd say that the practice that I've seen in different districts isn't as black and white as that. In other words, volunteers are sometimes hired and fired like a regular employee, and that muddies the water some. Employees who are volunteers are sometimes not really volunteers. They're given a pretty significant stipend, including a volunteer head football coach who makes $22,000 a year. That doesn't strike me as a volunteer. I understand how we've gotten some of the case law over time. There's a Kentucky case dealing with whether somebody's a volunteer and they're getting paid a stipend and therefore they're not being paid a salary. And so we hire them as a volunteer. I'm not sure that those kinds of sort of end runs fix the face law problem. And so I want to be careful that when we're classifying as people as things, we're not just utilizing a broad-based term to try to cover all situations and exempt people, that we're taking a look at the totality of the circumstances on the classification of employee before we take the position there's no way that person is subject to the statute.
And I would add something else to that I think is important. And one of the things that stood out to me, and we started to discuss this briefly before we started this afternoon, is Ellen and I heard an attorney this weekend speak from another state who doesn't have these legal requirements, who said that, her recommendation to her school districts is to do this anyway, regardless of state law, because of the number of child sex abuse complaints that she is dealing with and over time, and that this is just the necessary practice to do our due diligence with employees and others, even outside of a very specific prescriptive statute like this is. And it's in that same spirit that those sort of, are they an employee or not an employee category of people, are actually the people where this is the highest level of concern for me.
Mhm.
I see Ellen nodding in agreement there.
Yes, and that was something I sort of wanted to tag on to what David was saying in this effort to exempt people and to get around this process. I fear that we're not doing best by the kids and best by the spirit of the statute. We're here to protect kids. That's why everyone is doing the job that they do. So doing this process and going through it, even if you don't have to, even for coaches who are entirely volunteer, I think it's a good thing. And coaches are often those ones that have the boundaries that get crossed. Are they texting students outside of the proper Remind 101 app? Are they're in closer physical proximity to the kids? I mean, sometimes they're physically maneuvering, teaching kids how to maneuver their bodies. Those are the people that you do want to keep the closest eye on sometimes. And those are, frankly, some of the more prominent complaints that I see come across my desk.
Mine too. And that's why I share that concern is just because it's not mandatory doesn't mean that there's no liability for what those people do for the school district. And we need to keep that in mind as we think about this.
I agree.
So as part of this process, right, every applicant for the school district or one of our contractors, and I see some questions starting to pop up that we will definitely get to as we get there and walk through these things, but they have to go through a process where they have to swear and affirm that they are not disqualified from employment. We have to use an ISB template for that, in which they are disclosing to us that contact info for their current employer and any former employers who were schools, school contractors, or where the applicant had contact with children or students, that it authorizes us to go out and ask for that information, and a written statement from that applicant as to whether they have been the subject of a sexual misconduct allegation. Remember, sexual misconduct is as it was defined on that first slide that we talked about today, unless that investigation resulted in a finding that was false, unfounded, or unsubstantiated. And of course, lots of other things related to such an allegation within that definition as well. So this is an important place for us to keep in mind as we're talking through what those requirements might be and what it is that we are looking for and asking people to disclose. And of course, the role of the investigation becomes super important as well.
Yeah, and I think this is really going to energize a big change that I think started with Title IX. Ellen, I'll let you speak to that. But to my mind, this is going to change the way we do things. In the past, somebody resigned, it was like, not my problem anymore. You are out of here, goodbye. And then we had that first change to the law that said we couldn't agree to a non-disclosure agreement that we had to report. So we figured, okay, so we drafted form letters that went out to the state's attorney, went out to the ISB, and then we got out of the way and we figured this is not our problem anymore. And then Title IX came down and that changed some things. And I think this is really the final nail in the coffin of the idea that when somebody leaves, that's the end of our obligation. Our obligation runs no longer merely to the children within our district, but also to anybody with whom this person may have future contact. And the problem with that, I don't want to say that because I recognize that my words will come back to get me. I don't want to say that as an affirmative that it's clear there will be liability to a future victim, but I do want to acknowledge that some of the purpose of this law is to at least set up some procedure for us to go through in the event these things happen. And one thing I want to note in here is, unless the investigation resulted in a finding that the allegation was false, unfounded, or unsubstantiated, because one of my concerns is we have one of these very young teachers who is engaged in something that feels wrong outside those boundaries. Maybe that coach that Ellen was speaking about earlier feels a little bit outside boundaries, but at the same time doesn't feel like they made it. It doesn't feel like sexual misconduct. In the past, a lot of times our position is, look, not my plaintiff, not my problem. That person's gone and nobody got harmed. We're good. But the problem is if we don't complete that investigation, reach a finding as to whether it was or was not founded, whether it was or was not sexual misconduct as defined by the statute, we're now in this sort of catch-22 position where we may have to report it even though we don't think anything happened because we didn't complete that investigation.
And
Yeah, I also think you're less likely to get a resignation when someone is accused. I think that was something that used to occur is there was an allegation and the accused just resigned from their job and moved on. And I don't think we're going to see the same level of that. I think we're going to see a full and complete defense in their investigation to prove that it was false or unfounded or unsubstantiated.
I think you're exactly right. And I think that that's important. So the next requirement now is back on us as the employer or for the contractor to initiate a review of that employment history. So that employment history review process. It seems like everybody across the board has adopted EHR as the acronym, so we will too. Because in education, what we all lacked was one more acronym to learn. So EHR is that now for us. And so we are required to contact each of the employers listed and using the template form created by ISB, request the following: the dates of employment and a statement that confirms that there were no such allegations unless it was false, unfounded, or unsubstantiated, or that there is no knowledge that would disqualify the applicant. And as part of that process, we are also supposed to, for that applicant we want to hire, verify their reported previous employers through the ISB licensure database to make sure that someone wasn't left off. So, you know, this is that process where once those people are listed on that form, we're going to have to send it out to them, create that process, confirm that nobody was left off. And that process is going to be in full swing here very shortly.
Brandon, so I see a couple of questions here that I think we can knock off while we're on this slide, because I think that this one probably, at least for me, this one creates an enormous number of questions, and I want to make sure that that we deal with some of those up front. First, the statute as it's written, and there's a big highlight there, says shall initiate a review. Now, statewide agencies advise that they worked pretty hard for this particular language, that it's shall initiate a review, not shall complete the review. Now, I want to advise at least that we're paying attention to some of the issues that may come up around this. One of the issues that I want to make sure we're paying attention to is what happens, just some practical things. What happens if we're waiting? We wait the 20 days. Are we going to lose employees to another school district? Another thing that I want to make sure that we're pointing out is what if we don't wait the 20 days and something comes back with a positive finding on that report? What happens then? And I think all of those sort of put us in those catch-22 positions. And we'll come back to some of those facts later, some of those questions later, because I think they're important. But I think the narrow answer, I see Ed's question here. Each year we hire staff near the start of school. Can a teacher start teaching while we are waiting for a reply from a previous employer? And I don't want to give a straight yes or no, because there's some risk calculus there. Because if I initiate, what constitutes initiation? Does that mean I have to complete the forms and send it out? Does that mean that I need to wait the 20 days? I don't think that was the intent of the statute, and certainly it was not the intent of the agencies by agreeing to that language. But I think it's important that you understand that there is a little bit of risk once you initiate, not waiting for the completion of the process. Now, I also want to be not ridiculous, because I recognize that completion of the process would mean getting all the forms back, and we're not going to get lots of forms back. We send them to private employers, and we send them to wrestlers from 1994. We're not going to get those things back. But I think those are some of the questions you're going to have to ask yourself. And it may be a good reason, if you can, to get as many of those things done earlier as possible.
Yeah, I think a couple of things, and we are going to get into some of that in a little more detail in a little bit. I think the question of can they start is nuanced for a couple of reasons. One, as we're going to see in a little bit, the statute has different language for our own employee versus an employee of a contractor. And I also think we want to keep in mind the ultimate purpose and other liability pieces, because I don't want us to fall into the assumption that the only liability concerns are lockstep compliance with this statute, because I think even outside of that, there have been some long-standing best practices that we want to be thinking about as well. So I think that is an important piece about that. And I think the other part that does create sort of interesting statutory interpretation piece is there is a specific provision in the statute that says, for example, like with a criminal background check requirement, it specifically says an employee can start so long as it's been initiated. This EHR is not included in that section in that language. Was it intended to be by using the word initiate in this statute? Perhaps it was, perhaps it wasn't. What we see is the language is not consistent. And I have a law professor who would just complain about the fact that the people drafting legislation don't do so as clearly as they should, and don't use consistent language within statutes, even within the same section. But that's a battle for another day. So here's the piece I mentioned, is that the rule for our school contractors are different. And we see a question, that was asked, if we outsource busing, does this need to be followed by the bus company? And the answer is absolutely yes. And as a matter of fact, I think that the rule for them is slightly different, because for contractors, it says that this employment history review process has to be performed, which is different than employers, right? As the school, it says shall be initiated. For contractors, it says perform. And so there is, again, this inconsistent use of different language in the statute. So for contractors, it says it shall be performed either at the time of initial hiring or prior to the assignment of an existing employee to perform work for a school in a position that would involve contact with children. So clearly, yes, it applies to your contractors. They have to go through this process. And it appears from the language in the statute is that they absolutely must make sure that the process is completed, performed, prior to assigning them to do work for a school, which again is still somewhat ambiguous language, because the word performed, does that mean initiate or does that mean complete? I think that's there, and your contractors are going to have to struggle with that as well. But I do think we recognize that the language and the requirements for third-party contractors is slightly different.
And I've already had this come up in a bus contract where, or in a city contract where part of the city agreement was to provide some busing from the city using public buses for certain types of transportation, and setting aside some of the boundaries with regard to public busing. One of the things that occurs to me is that an employee who's newly coming into this new role, where they'll be transporting kids at certain times, even if they were prior in effectively the same role, but they're now switching on to a route where they're going to be seeing kids, they're potentially going to have to be doing, I think they are going to be having to do this EHR as well.
So, again, just to get through our summary here, and then we'll get to your questions. Employers, when they get those requests for that information, have to return that within 20 days. So we know for many of us, we will be on both sides of this, right? Not only are we going to be seeking that information for our potential new hires, but also for anybody who used to work for us, or maybe even current employees who are seeking employment elsewhere, we're going to have a responsibility to follow up. And so we have to provide that information. There is going to be a template going forward that anytime someone leaves our employment, we fill it out, and that's maintained as part of the personnel file. So in the future, it should be easier to respond to these, at least for school districts, because we will have been completing this template going forward. Obviously, that doesn't help us for employees who have long left us and we didn't do that. That is there. that if the investigation is then completed after that time, then we would update it accordingly if that was necessary. And that the information received is not a public record under the statute. We'll maybe leave for another day the discussion difference between received and sent in the statute. But that is there, and those are some of the requirements that are incumbent upon us. Any thoughts on any of those pieces, David or Ellen, before we jump ahead here to a couple more pieces on this? We have immunity for submitting the information unless it's knowingly false. So somebody sues us for providing that information. The statute does say we should be protected from that unless we provided something that we knew was false when we provided it. We cannot hire an applicant until they provided that information and we have initiated the EHR. Again, I think that there's some discussion about the intent and language of the statute about initiate, but that is the language that is there in the statute. That is the language in the press materials, even though it might not be consistently noted throughout the statute with some inconsistent language. We cannot suppress this information through contracts or agreements. So there is no way to say we won't share this information going forward, which I think, back to Ellen's point that it's going to be harder to get a resignation because we can't promise confidentiality about this going forward, but that's probably for good reason. It is required for substitutes. We're going to talk about substitutes more here in a little bit in a second. Again, contractors are required to go through this, and we can do more. We just can't do less. Right? So I think those are some of the other key moving parts in the statute. And I think the final piece here in terms of summary on this section of the statute of 2294 is that if an applicant has undergone this review and wants to transfer to another school within the same district, diocese, jurisdiction, or supervised by the same organization, we don't have to go through this process again. But if they're going to another district or organization, then it would be required. And I think that language is also a little ambiguous because it talks about an applicant who has undergone an employment history review. So if you've got a 20-year veteran teacher who wants to transfer to another building, right? If they haven't undergone the EHR, is it required? I think the statute is written ambiguously about that, and I am concerned about that language. David, a thought about that before I go to the substitute piece?
Yeah, this is a big one for me because I have absolutely no idea what that means. They speak to what there's a Latin term from law school that I've since forgotten, inclusive of one to the exclusion of the other. I don't know what this is intended to mean. For the record, I've seen lots of firms who are advising that any internal transfer necessarily kicks off EHR. I don't think the statute technically says that. However, I also don't think that's an unfair read of the statute's obligation. As Brandon said earlier, and I think as Ellen said earlier as well, just because you're not required to do it doesn't mean you can't do more. And the fact that the statute specifically refers to a particular type of transfer where it's not required does seem to imply or that maybe that was the intent of the drafters, was to require that for any transfer. And I can't tell you that beyond the shadow of any reasonable doubt that it couldn't be required for any internal transfer. Look, is it likely that one of these folks who's been there 20 years is going to be somebody who comes up? I expect not. But I can also tell you that I've never, ever, ever had a grooming situation where somebody said to me, oh yeah, everybody knew that person was a groomer. In fact, I don't know about you two, but every time I get the call, it's, oh, that's the last person I ever would have gotten. I never would have guessed that person. And that's what this statute is designed to correct.
Yeah, well, but I also think where some people are saying, well, they had this unfortunate situation with this student in this building, so we'll just move them to another building and give them a fresh start. I think that's
exactly the situation that worries me. Yeah.
But that doesn't necessarily disqualify them from employment in that building. Having an allegation alone wouldn't be disqualifying. It would just be something that was noted on their employment history review.
Well, then we would have to do an employment history review before the transfer, I think, is maybe the piece. You're right. I mean, we may end up doing, I think, Ellen, you're 100% right. It's not going to prevent us from making the transfer, It just might mean we have to do the EHR before the transfer.
And that's
Yeah.
probably a best practice.
But it's going to make a lot of people uncomfortable.
And that is understandable.
And maybe the piece that I've heard the loudest complaints about is the substitute provision. And I get it, so don't shoot the messenger here a little bit, but the statute specifically says that the appearance of a substitute on one school sublist does not relieve the other school from doing an EHR and complying with this. I know in many places, for example, maybe the ROE or other entity might do like the criminal background check process for a sub so that everybody, doesn't have to repeat it. This statute specifically says that everybody has to do their own EHR for a sub to be on the sub list. And gosh, that is going to make it really hard to have a good sub list or add people to it. That is, I think, going to be, I get the concern around that for sure. And that's the way the statute is written very plainly at this point in time. Maybe that's an area where we could seek some amendment to the statute, maybe what we could get some of the organizations to think about that process, but do recognize that language about subs.
And I think that another thing I've heard a whole bunch of, and I think we'll probably cover a little bit more later, but is companies who are going to sort of keep broad lists for folks so as to theoretically immunize the school district against this process. But I'll point out two things. First, the company doing it for themselves is not a substitute for doing it for you. And second, any mistake that's made in that process is that liability is going to be borne by the school district. Certainly there's some things you can work into contracts with those companies, but I don't think that there's going to be a way to fully shift the totality of liability to a third party. And so I think it's important that the school district is aware of what's occurring and is at least particularly in these early days that we're having some engaged oversight over what's occurring and what it means and whether we're being compliant.
So I see lots of questions about subs. We're going to get to the questions here in a little bit. I want to mention this other piece first, and then let's just jump into the questions. And that is the other provision separate from the EHRs in 102.702, which relates to parent notification. And so 2285.10 is a new section of the school code that says that whenever there is an allegation of sexual misconduct from an employer, agent, or contractor of the school and a student, we are required to notify the parent or guardian of the allegation, and then also when any formal action is taken against the employee, including accepting their resignation. A couple pieces to this: that we're required to notify the student first that we are going to notify the parent, and we have to do so in a developmentally appropriate manner, that they are notified in writing as soon as feasible, subject to any CAC requirement. So if DCFS or CAC is also investigating and they say, hang on a minute before you notify the parents because it might affect our investigation, then we will coordinate with them. Starting in 2025, it's also got to include, our domestic and sexual violence and parenting resource coordinator, which we will all have by 2025. That's a separate bill that happened last year that we've got a couple of years to worry about. So we'll talk about in a webinar next year when we're getting ready for 2025. We don't have to notify parents if the student is 18 or older or emancipated. Again, we work with DCFS and law enforcement on the timing of that. And we don't have to do so if the parent or guardian is the alleged perpetrator. That is there, and that there is sort of an exception if there was an imminent risk of serious physical injury or death. But that is otherwise we would walk through that piece for us. Any thoughts on the parent notification requirements before I get to one other notification piece, and then we'll just jump into questions.
I just want to know that that's a great place to be doing your Title IX intake as well, because if you have actual notice that there has been an allegation of misconduct by a employee against a student, you have an obligation under Title IX to do an sort of an intake meeting where you discuss the supportive measures and you discuss how to file a formal complaint under Title IX. I think you group all of this together. You're already including the parent in that if the student is a minor, unless there is some reason not to. I think this is wholly on board with that. And I think you can combine these two obligations and get it all done at once.
Absolutely.
I agree.
One other notification requirement is the statute also said that anytime that we have reasonable cause to believe that an employee has committed an act of sexual misconduct, and that resulted in their dismissal or resignation, that we have to notify ISB and the ROE. So also notice in that situation, so reasonable cause to believe, and they resigned. So there is a separate notification requirement here that we're going to have to keep in mind as part of that process going forward for us. So let's figure out what all this means. So David and Ellen, we've got lots of questions in the queue. We sort of anticipated some of these. So, David, do you want to kick it off with any further thoughts here about the volunteers? I know we talked about that, and then we can start going through the queue here with some of the questions.
Yeah, so I mean, with volunteers, are volunteers actually being hired? I think that's going to be a key and critical component. I know lots of school districts, particularly larger school districts, that when a classroom volunteer comes in, they still make them go through the criminal background check procedure because they've determined long ago that even though it's not required by statute, the idea that you're bringing a convicted felon into schools who may have had sexual misconduct in his past and is like, there's a gap in that criminal background check statute that deals with particularly old offenses with regard to sexual misconduct that fell off after 21 years. So that's there was the thought that maybe we want to go ahead and do those, and that way we know, because these are people we think we know, but we don't necessarily know where they've been in their lives. And so if we're going through that process on those folks, it might be worth a conversation about whether we should also be going through the EHR process as well for that same reason. Are they actually being hired? I mean, again, if they're volunteers, they're theoretically not being hired. And so I think that it's not the intent of the statute to deal with volunteers, but that is something to be aware of. Also look at that direct contact with children or students, which means the possibility of care, supervision, guidance, or control of students or children or students, or routine interaction with children or students. That's obviously a pretty broad it's going to cover most people in your school. But again, looking at where that volunteer is actually serving may be important for those purposes.
Yeah, I think there's a difference in my mind between, that volunteer assistant volleyball coach who is going to be at every practice and on the bus and all those things, where I have, I think that's still best practice, even if they're not being paid. I think that's different than the parent who's coming in to read in the classroom, always under the supervision of the classroom teacher. I think though, you're right. I think those are very different situations, because it is talking about routine interaction, right, or care, supervision, guidance, and control. And I don't think that parent who's coming in to be a classroom volunteer, or who's bringing snacks for the Halloween party and being there during the Halloween party is doing these things.
But if you've got the parent who's sort of that volunteer aide, where they're really functioning in the classroom as a full-time aide, they're there every day, they're really operating like a school employee, except that they're volunteer, but they were hired by board action, that they were agreed to be a volunteer by board action. There was a criminal background check. That person starts to feel, to me, an awful lot like somebody who can create liability for the school district. And that's the point at which I'm no longer thinking, I'm thinking we may have crossed into a different boundary. But again, I think that totality of facts matters on each one of those situations.
So what if the former employer submits late and there's something relevant there? And what if it comes back? What if the person's already started and now we have some information that's concerning? Does that mean we just get to take their keys and walk them out to the parking lot and say, thank you for your service?
It's always going to be fact dependent, if you ask me. I'm going to want, look, at that point, that person, once they've been hired, we've initiated, which means we didn't hire until after initiation. We initiate the process, send the forms out, then we do the hire as required by the statute. But we don't wait until the end of the process. We just go ahead and get them into the classroom, as we have to do when it gets to August. It's just a practical reality. It's got to be done. My concern at that juncture is that additional information becomes something that, like everything else, is going to subject the employee to some sort of due process, is going to give the employee some due process. And we need to determine what is the nature of the allegation, what is the viability of that allegation, was that transparently provided, what is the actual violation of rule or of substance that we can point to that will allow us to ultimately cut off that employment. We don't have any case law on this yet, so I'm very hopeful the first case that comes up is a great facts makes great law case, where it's just horrible and the court says, procedurally, the minute anything comes up, that's it, you're not being employed. That'd be great for all of us. My guess is that bad facts make worse law. And we're going to have one of those cases where it's a really close call and the court says, no, you've got to have independent information. And that's why I want to make sure that we're evaluating each one on a case-by-case basis and not taking a flat yes or no position.
And I think it's going to depend upon where they're at in terms of, is that a position in a bargaining agreement? Is there a probationary period? Are there rules or policies about that, so that if once they've started and once they're an employee, in some districts, there might be a probationary period that matters for a non-certified employee. In other districts, they're going to have all the rights on the first day they start in terms of the amount of process due. And obviously for a teacher, things are going to be different there as well. So I think that all those facts matter as we decide what we would do with that information. And I think this next question is one that does stand out in all those circumstances, whether it was timely or not. We get back information, there was an allegation because there was no conclusion to the investigation. And that's the part, Ellen, you initially said earlier, we want to try to avoid that going forward by making sure that we complete investigations, but we all know there will be situations in the past where that may have occurred.
Yeah, and I think that under Title IX, you have the ability to permissively dismiss a complaint where the respondent is no longer a part of your educational program or activity. Here, if you want to be a good neighbor, it might make sense not to dismiss. Or for the first time ever, you may have a time where you're dismissing a complaint against a respondent, and they might appeal it because they want a conclusion. I think that could be a really interesting issue under Title IX that they never anticipated would occur. And all of this, of course, is subject to change because we may be getting new rules very soon.
Yeah, I think the Title IX piece is also, we don't know what Title IX rules are going to be for next year until they release them, and they haven't released them yet, but we anticipate we will have new Title IX rules for next year. But I think that point is really an interesting one where the employee might actually want us to finish the investigation just to be able to not have to say there's an open allegation for future employers. I think that is going to be really, really, really an interesting one for us. And also, if people are trying to go find jobs, they're going to want us to complete that investigation before they have to even go apply, because they're going to have to sign a form, in that regard. And so the timeliness and the amount of time those investigations take also matter.
So do you think we could be in a position where you had to sort of investigate conduct that occurred in another district?
Well, I think that leads us to that next question, where you have a response that's vague, that implies a finding, but doesn't really say that. I mean, so what do we do with that information, David?
Well, so, I mean, I think the question is well founded. Are we going to have to investigate what's happening in another district? And I think it brings us back to the answer in the last question too. That Ellen, you said we may have some employees who want to complete the investigation, make sure there's no finding. I think we may have some employers who want to complete to make sure there's a no finding, so that we don't get into this situation where two employers are arguing about what information will be shared and how much investigatory authority that you'll have in another school district. I think this really puts a spotlight on the need for a complete investigation at the time the conduct happens. One of the things that worries me the most, I think, is these situations where we may be getting information back from the YMCA about something that happened 22 years ago when somebody was just barely 18 years old, and we get sort of this blank form statement that's just there was an allegation and we don't know anything about that. There's an allegation in 1994. I don't know what that means, and I don't know how I'm going to even investigate that. But I mean, again, I think that there may be an instinct for all of us when we see that to go, oh, I don't want this person here. And I think that before we jump to that conclusion, it's going to be very important that we take that form and we think mindfully about what it is we've got and what information is there, and that we use that as a starting point for our investigation, not an ending point.
And I think that's a really important point, David, because I want to put in the context of another legal requirement that we all have that I'm not sure we're all following. And that is the requirement that's been in place for now almost 2 years related to criminal background check investigations. And if you all pay close attention to your current version of your policy 5:30 and its related administrative procedures, we know that in 2021, when criminal conviction became a protected class under the Illinois Human Rights Act, that there's a new required process for back and forth, so that if you get a hit on a criminal background check and you want to not hire or exclude that employee on the basis of that criminal conviction, we are now required to give them notice in writing of that with an opportunity to respond to that before we make a final decision about hiring. And I would suspect that a similar or analogous or identical process, frankly, would make sense here for that.
Agreed.
Whether it's vague or whether it's clear, I think I would probably use the same process that we're all getting used to with those criminal background checks.
Yeah.
Absolutely.
One more question here that I do think is an important one from a liability perspective, frankly, before we get to all of the great questions in the queue that keep popping up here. So we're going to jump to that here in just a second. You know, what happens to a school that fails to comply with the 20-day disclosure requirement? And obviously, I think that is a liability concern, because I think that failure to act, particularly if there was an issue and then something happens in the new district, you know, we see some case law in some other Illinois school districts over time where that was a problem, you know, and so I don't want to overlook that could create some concern for that school who's failing to provide information that they are required to provide.
Yeah, I mean, I think the plaintiff or in addition to having a plaintiff problem, you also have a co-defendant problem. You have a problem where one district or one employer might attack another, arguing that their failure to turn that information over to them subjected them to liability. And you know, this gets into that question of what constitutes a breach, of immunity. And remember that in the statute, one of the things it says is knowing. If you knowingly fail to follow the statute. And so I think that's one of those things about not just about being a good neighbor, but also remembering that we're protecting our liability shield when we comply with the statute, whatever that may be.
Well, friends, shall we jump into the questions in the queue? And do you have any particular question you want to start with first, or should we just walk through them in order?
Let's go through them in order.
So first question up, I think, goes back to the underlying original faiths law and that employee conduct boundaries. You know, if an employee texts or messages with a student via social media, are there criminal charges attached to that, and what is the penalty? So I think the answer to whether there are criminal charges is going to depend upon the content of that. And so if it does, in fact, involve any sort of sexualized conduct, then I think that is a violation of the grooming statute. And is electronic communication is criminal grooming if that is a minor. And if I recall, that's a class 4 felony.
I think that's right. But remember that for the definition of grooming, it's not what we routinely refer to as grooming. It requires an act to solicit, lure, attempt sex. It requires that there be some proof that there was an attempt for sex and that there was an intent for sex. And the proof of that is really, really complicated. They've got to prove that somebody is actually there at the receiving end, and that it was known who was at the receiving end. They've got to prove that the person who was sending it was intending to be the one who was sent it. And one of the things I've discovered is states' attorneys are very concerned about overcharging that.
But I think outside of the criminal piece, I think that that is a violation of policy and is a boundary violation. And the statute says a violation of our employee code of conduct policy can lead to discipline up to and including dismissal. And so I think that there are absolutely employment considerations related to that. But in order for there to be a criminal penalty, it's going to have to fit within that category of grooming.
That's right.
The next question here, I've received a frontline request for a former employee from a school district in the state of Oregon. Have you heard of this being a possibility to try to ease the burden of requesting EHRs? I'm going to presume that that's a company that does those checks. I don't know if either of you are familiar specifically with that one. I assume that that's what that means, where instead of it going from the school district, that there's a company doing it on behalf of, is the way I read that question.
That is accurate. I have just Googled it.
Thank you, Ellen, for confirming my suspicion based on the question. And I think, David, you talked about this a little bit, or maybe it was, I forget which one of you, when you're hiring a third party to do that, ultimately it's still the school district being responsible to make sure that it is completed. So, I think you just have to exercise good judgment in that regard. I'm sure there will be companies and organizations who are seeking to fill this market. And there may be times where that is appropriate potentially, but I think we want to make sure that as a school district, we understand ultimately what our obligation is, and that liability is well assigned in whatever agreement you have with that company who's going to do that on your behalf.
Yep. Yeah, and there may be a limit to how much of the liability we're capable of passing. We don't totally know that yet. So it's going to be important to be assertive in that process and knowledgeable about what it is that is your responsibility and what's being received, and that those things aren't happening, particularly where we're punting people, that we're not doing it just sort of on a check the box automatic version, that that you're retaining some responsibility for making those determinations, or if you're not retaining the responsibility, that whoever is doing it on your behalf is doing so with knowledge of those due process requirements to make sure that those are being completed.
So we've got several questions here related to the application process. So should we add these forms as part of our application process? Should we have every applicant automatically fill this out? I think, just to give the technical reading of the statute, it says prior to hiring an applicant. So I don't think the statute requires you to do this process for every applicant. I think it requires you to do this process prior to hiring the applicant you want to hire. I think that is what the statute plainly says. I think that there may be some pros and cons to exactly what we want to, whether that makes sense to do as a process. And I'm interested to see what you two think about that as a process piece.
So I have ways in which I like this and ways in which I don't like it. And I think that some balancing of the risk is important. So one, I've heard already from lots of employers they're doing this. And I think getting a sense of what others are doing, what is sort of common practice. You guys have heard us before a number of times about sort of, as new laws come out, one of the first things we do, we are not usually the first out with a conference on it. We tend to listen a lot and try to understand what others are doing and try to get a sense of how we're going to make our best defense by sitting in the middle. And so I think that's going to be important in your region, sort of understanding what others are doing and statewide. I think that's a big piece. I think another thing that you need to be aware of is that part of the reason that criminal background was added as a protected class within the Human Rights Statute, the Human Rights Act, is because the identification within an application of somebody's potential criminal background tends to impact, in particular, minority communities pretty heavily, just statistically. And therefore, people may not just, it may not be just a function of the fact that they're afraid to answer the question. They may not even apply for the job in the first place because they find out about the nature of the application. And so I think that you need to think about how that's going to impact your actual applications. But that said, the statute also permits you to ask those questions when those questions have a disqualifying effect. So in other words, if you can't pass a 10-21.9 background check as required by the statute, you're entitled to ask that sort of on an open-ended basis. Can you will you pass a background check as required for the position? That's a legal question. And so I think that that's also true for the face law trailer bill. Is there anything you need to report? I think is a viable question. But again, this is a new law, so we don't really know what DHR and EEOC, Department of Human Rights, and the Equal Employment Opportunity Commission are going to do with these different fact patterns. So I think it's a viable solution. I don't know that it's risk-free.
And I think a related question I see is, do you suggest using the ISB forms or creating your own? And a statute specifically requires ISB to create a form. And so I would say use ISB's form.
Yeah, agreed. And one of the things I heard at the conference down in Southern Illinois last week was they're not called forms, they're called templates, because ISB insists they're called templates. I don't know what the distinction between form and template is, but I thought that was amusing.
I think the implication is that if it's a template, you can use you can
make it your own. Yeah, and therefore it's ours and not their liability. Yeah. I understand what they're after. I'm just not sure I'm willing to support it.
So a question here about, does the law apply to a student who's 18? And I think based on when that question came in, I think that was specifically related to that definition of sexual misconduct. And the statute does not separate between a minor or an 18-year-old student for purposes of what is sexual misconduct. So while it may not have the same criminal implications for an adult student that it might have for a minor student, the sexual misconduct piece to it still applies the same in terms of what we're reporting out. Either of you disagree with that?
No, that's spot on. It says with a student.
Yes.
Statute.
Nothing in the statute that suggests that it's limited to minors. So several questions here about contractors. And everybody seems to be particularly interested in HVAC contractors, it appears, as the examples they put here. But if someone is coming in to fix the heat goes out, do they have to go through that requirement? And I think the answer comes back to this definition here we see on the slide about what direct contact means. So I don't think that the contractor who's coming in to fix the HVAC is going to have the care, supervision, guidance, or control of children. Would they have routine interaction with them? And I think the answer to that in most cases is going to be probably no. But I also want to make sure that we have some understanding about supervision. I think there's a difference between the one person who's coming in who we kind of know where they're at and are supervising them at all times, and they're working on that maybe alongside our own employees or our maintenance people, and maybe somebody who's there as sort of a general contractor doing construction, and their employees are coming and going and children are there too, and it's a very different level of supervision and control. I think those are slightly different situations for me, but I don't necessarily read this to mean it's the HVAC guy who's coming in to work on the system on a one-time basis or something like that. Do you disagree?
No, I agree with that. But I will add one nuance that particularly in the small school district where we have that sort of maintenance guy who's in all the time for, we have a custodial staff, but we have a maintenance guy who's in all the time, and he's dealing with sort of higher level issues. But he's there constantly. He's, a light bulb goes out, he's the guy. Toilet goes out, he's the guy. And if he's regularly going to be in routine contact with the children, then that's the point at which I start to feel like either I need to establish a different protocol with him to assure that he's not in routine contact with students. I think that's a viable way to avert having to go through an EHR process, or alternatively, go through the EHR process before he comes in the first time. That way, there's just no question because we've got the EHR completed.
So
I agree, but I do just want to add that the contractor is defined in the statute to include some examples, and those may be helpful for everyone here to hear, that it's including but not limited to food service workers, school bus drivers, and other transportation employees who have direct contact with children or students. So those are who the statute anticipates are going to be in direct contact. So you could think about whether those individuals are going to be in that same sort of contact.
I think that leads us to another question here in that regard. What about athletic officials?
That's somewhere in between.
And I think when it's somewhere in between, I probably lean towards yes.
And that's certainly not going to help get athletic officials when there's a shortage, but I think that is the right answer.
Yep.
That question was in there a few times
Yeah,
for us.
it's the safest answer. Look, one of the practical realities about what we do is we're in dual roles, right? We defend you when something goes wrong, but we also try to help you avert having to be defended. And so as we sit here and the three of us pontificate on, we sort of do funny things as we're in here. On the one hand, we're thinking about how we're defending you, and so we start to give you good arguments for defense. But on the other hand, we also try to be practical and help you do what you want to do. And on the other hand, we try to help you avoid all of it. The reality is your district, as you work through these things, it's going to be a little bit of fumbling at the beginning, but we're also going to have to decide where our risk tolerance is. I think some school districts are going to very rationally take the position, look, my maintenance man isn't coming in nearly often enough that I'm worried about it. And frankly, I know my maintenance man, this isn't going to be an issue. I think they're also going to take the position, look, I know those fit officials, these are folks who've been here for a long time. I'm not really employing them. I can think of 16 different arguments. We're in the midst of a shortage. I'm not going through this. And I'm not going to tell you that I think that's an unfair calculus. I also think that as we're in that role of trying to help you give you the safest answers and the safest practical, how do we avert liability? Yeah, you're going to do more of this, not less of this. And I think finding where you are on that boundary of risk is going to be important for every school district.
And I think that is such an essential point, not only on this topic, but so many, David, but I think that so much of what we do, right, there is a difference when I'm in that advisor role and when I'm in that defense counsel role in terms of, what we want to be prepared for. And I think that it could be really easy to just give you the answers you want to hear and then go out and defend you when you get sued. But I don't know if that's in the best interest of the school district. I want to make sure that you and your boards have had a chance to really think about these issues, think about where the risk is at, and then make some policy decisions that work for your community, that work for your students, and that's important. And what I've already realized in so many of my conversations with folks on this topic is that not everybody is landing in the same place on that continuum. And that's okay, because we all make different decisions about how much risk we're willing to take on. And so, all we can do, especially with a new statute, is take our experience and filter it through here to help you think about what that risk calculus is. And so it's important that you're, working through those issues in that way, because there may be things that we all think are clearly the answer, and a judge in a couple of years may have a totally different view when looking at it for the first time for whatever reason. So I do think that is an important thing for us to keep in mind.
Brandon, I've seen a couple of questions in here about when we start this process, whether we've got to start it after July 1st or whether we start it beforehand.
So I think that is a question that comes back to the vague and ambiguous language in the statute about what it means to hire. And the reason why in my role, as I sit at the bargaining table and look at policy and look at practices in so many districts, is that we sometimes use the word hire to mean different things. And so we've got to figure out what does the statute mean by it? Because, for example, a lot of us may have in our collective bargaining agreements definitions about hire date, for example, that mean different things. Is hire date the date the board voted? Is hire date your first day of work? And I think, as I'm thinking to a future lawsuit, it's not irrelevant to think about how we, through policy or collective bargaining agreement or practice, have defined hire date. And so I am cautious, and I know this is driving you all insane, and there are people throwing things at your screen because you just want a yes or no answer from me on this. And I want to just give you a yes or no black and white answer too. And I did to some of you. Some of you I see on here, I've talked about this, in different workshops at different places over the last couple months. But I think as we all are learning some nuance here, I'm starting to recognize that the definition of what it means to be hired is not the same in every school district. And so I think that there is some risk in saying, I hired this person in June and they're not starting until August. And so therefore I hired them before the statute took effect. I think we need to have a little bit more of a nuanced view of what that means in terms of hiring and hire date for future liability purposes. I don't, I think you're in the same place based on our prior conversations, but can you improve upon my thoughts on that, David?
No,
everybody hate me less now.
No, I mean, we 100% agree. In fact, I think that Brandon and Ellen, when we had our firm meeting, we were sitting there talking about hire dates, and I had come up with, I think I had come up with 3 on my own that were potentially there. And then the rest of the group came up with 3 more, and we were up to 6 potential different meanings of the word hire. And this is one of those, it sounds like a real lawyerly exercise to define the word hire, but this is the kind of thing that confers liability. So look, it's another continuum of risk issue. Do you want to take the most ridiculous, aggressive, conservative approach that every single person should do a EHR regardless if they've been hired? Okay, we could take that position. I had one employer call me and say, there's another firm advising that anytime anybody's transferred anywhere, we have to do an EHR. And does that mean that when we do our motions to rehire everybody, as we long have in our school district, whether we should be doing those or not, does that mean we have to do an EHR for everybody? And they told me yes. And is that true? And my answer is, it depends on your risk tolerance. I just don't think that there is, because the statute is not clearly written on that point. I don't think that I don't feel comfortable giving you a straight yes or no, because I don't think the statute gives you yes or no. So it comes down to your risk tolerance. I think that if you want to have the best possible risk tolerance, you want the least amount of risk, do more. If you want to take on a little bit more risk, do a little bit less. I know a lot of people are taking the position, I'm going to hire everybody now and get it done before July 1st, so I don't have to contend with this until next year, and then I can learn from other people. Look, I can defend that. The statute is the statute. It says July 1st. So if that's the answer you want, I'm not going to tell you that that's an illicit answer. I think it's a viable answer, but I will say that it takes on some risk, because particularly if your collective bargaining, as Brandon said, if your collective bargaining agreement or your policy refers to hire date as a different hire date, as a different date, the day you start work, for instance, as your date of accumulation of seniority for purpose of hiring in the seniority list, just be aware that you're taking on some risk about a conflict in what constitutes a hire date.
Now, many of my conversations have told me, David, is that people are choosing the path you just described, which is we're going to hire everybody in June so we don't have to go through this process. And again, I can defend that, but I don't want to suggest that that is a totally risk-free decision to make. And you're going to have to think about that. Lots of questions in here about substitutes. So I'm going to ask several of them sort of simultaneously. And I see some of our friends from our ROEs who we love and are appreciative that you joined us today also have some questions about that too. The question is, are you saying that the ROEs cannot do us like they are doing for criminal background checks? I'm not saying that. The statute says it. I mean, the statute, I guess they could, but they're going to have to do it for each school district, and if somebody starts anew in a new district, the fact that it's already been completed in another district doesn't relieve that district of its responsibility. And so I think we have to look carefully at what that means. Now, I see some questions in here about people who are already hired as subs, they're already on our sub list. I think that is part of our recent conversation about what it means to be hired, is being on the sub list, being hired or not, and whether that is a viable place and where we want to place the risk. But the statute is pretty clear. I'm just going to slide back to that slide because I think it, clearly states it, right? That it says that the appearance of a substitute employee on one school substitute list does not relieve another school from complying.
Yeah, and again, I'm going to come back to that question of what constitutes hiring for that purpose, because I have, not to speak out both sides of my mouth, but I have made the argument that a substitute employee is hired every time, is hired on a day-to-day basis, that we're not necessarily hiring them once for the year. And so one thing I want to be alert to is if we're making arguments that come out both sides of our mouths that aren't viable when we're taking a position that somebody who's newly added, for instance, to the sub list doesn't have to be, or who's been on the sub list for a long time, it hasn't been called for a long time, and now gets called, we're going to argue that we're newly hiring them. They don't have a reasonable expectation of continued employment, but at the same time, we also don't have to do any EHR. I just want to make sure that we're considering and contemplating our risk as we make those determinations.
And I think that that's part of the intent of the statute with the language of substitutes, is recognizing somebody might have subbed for me 6 months ago and then gone and done something bad in another district in the meantime, and I didn't hear about it unless I've gone through this process. And that's what this is intended to catch. Does it make our lives harder when we can't even find subs as it is? It does. But the purpose is there, and I think that's important for us. All right, I'm going to start going through these in order here to answer. Again, do we need to initiate the EHR prior to board action to hire, or is it prior to start date? Statute says prior to hiring. And again, in some districts, hiring is defined by CBA as start date. Some people are going to say it as board hire. I think clearly we have to initiate it before they start. I think there is a fair reading of the statute that would say prior to the board hiring them. I think there's a related question, saying in today's hiring environment, should we make an offer to a candidate pending the review in order not to lose the candidate? I think those questions are the right questions. I think they are clearly thinking through. It's showing me that you're clearly thinking through, the ambiguities inherent in the statute. And my view on that is we're going to have to create a system and a process that we treat everyone consistently through. I think the cleanest practice is prior to the board hiring them. Not every district is going to order the process in that way, I suspect.
Yep. And I've started adding contingencies on the hiring motions everywhere just in case, to add myself additional protection.
What about student teachers and interns? Is it the same analysis as volunteers? And I think the answer to that is, in most cases, it is the same analysis as volunteers. I think there are some cases where it would affirmatively be required because the statute does permit us to pay certain interns and student teachers now. And obviously, if we are doing so, then I think it clearly would apply in that situation.
Yeah, I know ISB has taken the position that it doesn't apply to student teachers, but be alert that answer is silent as to the paid student teacher. So if you're making the election under the optional pay procedure, if you're making the election to pay your student teacher as an employee, then be alert. I mean, setting aside whether the schools will even permit you to do that, because I'm aware that some universities have rejected that. Be alert that you're turning that person into potentially an employee for purposes of this statute. Thus, an EHR would have to be I shouldn't say have to be required, but at least would arguably be required.
What about other programs that use our buildings where they're not our employee, like an after-school tutoring program where an organization uses our building, but they're not paid by the district? Is the EHR required?
I mean, I think the answer here is, just rereading this question, I'm going to add a word, their employees are not our employees. I don't think we're required, when we lease space to someone else, we're not required to conduct an EHR. In the same way, we're not required to conduct just an analogy, different statute, but we're not required to conduct a criminal background check on every place that utilizes our building. But again, this is where I want to make sure we're dealing with somebody who's not our employee by any purpose of the statute.
Yeah, they're not our employees, but we don't make them fill out the use of facilities form because we've had a long-standing history with them. And we don't make sure that they have insurance because we like them and they provide a lot to our district and to our kids. And
we walked into our pet peeves now.
I think those types of things where we're, again, not treating third parties as third parties may also confer some liability. So I think those are the right questions to ask, and being able to make clear that it lands where you said it did, David. Yep. What about an employee who is accused of sexual misconduct against another employee? Would this be reportable if it wasn't involving a student?
So the statute says student. Statute, I think the statute says student. Explicitly refers to students and children. It does not refer to employee on employee misconduct.
So I want to ask each of you a question about this. I'm going to ask Ellen this question first. But with an employee sexual misconduct allegation against another employee, we still have responsibilities, right?
Oh, sure. You still certainly have responsibilities. You have responsibilities under Title IX. You have responsibilities under the Illinois Human Rights Act. But you have luckily gotten out of them under Faith's law. And
David, just because it's employee-to-employee conduct doesn't mean we can't report it to a future employer. There's just a difference in terms of it being included as part of this EHR process, right?
It's not part of the EHR, and I'll point out that employee-on-employee misconduct may also be the kind of misconduct that you're prohibited under the law from non-disclosing upon separation agreements. So when we're looking at sexual misconduct of any sort, reporting it appropriately is important, protecting the information is important, and carefully considering how we report what we know. And by the way, this is a place where I think Faith's law does us a huge favor. Because I can't tell you how many times in my career I've had to think about a case from 5 years ago and how we report something that happened 5 years ago that nobody contemplated 5 years ago when it happened. This law requires us to contemplate it at separation. If we're not thinking at the point of separation about how we're going to report this going forward and how we're going to keep ourselves directly to exactly what we know and can prove, but also report that accurately, not covering something up, I think is going to be really important. 15 years ago, I heard an administrator, I was speaking with an administrator, and he said, I have a problem with passing the trash. He said, this guy over here is going to tell you to write a non-disclosure agreement, and I'm going to tell you don't ever do that. And first of all, I didn't say that. But second, he was right. I thought he was right at the time, which is what I said to the group. And I think he's right now that it's important that if we have a known issue, a known offender, that we are not simply taking the position that this law doesn't require us to report it, so we're not going to affirmatively report it ever. We need to be careful about how we're passing that information along, though.
Yeah, I think that's essential. And you know, we have got separate statutes that say we can't we can't have a non-disclosure agreement related to sexual harassment. As a matter of fact, if there's a separation agreement with someone where there is an allegation of sexual harassment, we actually are supposed to post that on our website. So there are lots of different requirements in that. A comment that the ISB template says employee misconduct. I'm not seeing employee misconduct on the ISB template. I'm saying if an employee has misconduct against a student on the ISB template, I'm not seeing that on the template. So I don't know if either of you want to look at that too. I don't see it. So let's go through here. We've got about 5 more questions. So let's jump through them. What employee code of conduct should we use? The educator ethics. Well, you're required to have an employee code of conduct that addresses certain things. It has to incorporate the code of educator ethics as part of that code of conduct, but it's not only the code of educator ethics that has to be included, and it requires some local decision making. Again, there is a template for that in press policy 5120 attached to that. But it's not only the Illinois Code of Educator Ethics that has to be included in that code of conduct. It also has to set expectations for staff-student boundaries, and it has to have those other components that David talked about in terms of, transporting, taking or processing a photo or video, or interacting outside of that professional role. If an employee is off in the summer, should we do an EHR for summer employment if it involved children? So if this is an existing employee, as I understand it, right? They're not newly hired. I don't think we have to go out and do this for existing employees. But if we have a new employee who is starting, then it says their current employer and all previous employers that involve children. So I think that it would have to be performed for a new employee, but not for an existing employee. You guys think about that differently?
No, I want to give the commenter or the questioner attention for listening really closely to what we said, because we talked earlier about, I think this question is generated because we talked earlier about the whole purpose of the statute is if you go out somewhere else and then come back, that there could be something that happened there. But I think the statute still does, the one place where I think the statute is pretty clear is for existing employees where there is no other change by the employee or the employer within their work environment. A second grade teacher is going to be a second grade teacher, is going to be a second grade teacher, is going to be a second grade teacher. I don't think there's any requirement that we go through and do a new EHR. I just think that's one place where the statute didn't require anything new.
A couple quick ones here to mention, and then I've got a couple that I think are thoughtful questions that will help us, I think, wrap things up. When can we expect a form from ISB to use for this? Those already exist. They've had them out for a month or so now. So those templates from ISB already exist. If we investigate the allegation and it is unfounded, we are not required to report it, correct? That is correct. It would be, you would check the box. There is no allegation that was not investigated and unfounded. So that would not be reportable if it was investigation complete and unfounded. And can you confirm again that sports officials are included? It is hard enough to get them to submit their tax paperwork for a W-2. I have a real hard time finding an argument that they shouldn't be. I mean, that's where I land on that.
Yeah, I mean, I could argue it. Do you want me to? That's I think that's the fair read of the statute. And for the record, I've heard the folks who were involved in those negotiations talk about that a whole bunch of times. And as I'm listening to them, I don't hear that their answer is markedly different. I've heard the same thing that, that's an open question. It's not very clear, but clearly they're having routine daily contact with students. Clearly they meet the definition of employee of someone. And so the idea that they're not at all subject to this seems hard to defend. And if IHSA is not going to do it, then that sort of leaves us.
And I have a hard time getting out of my mind cases I've had in the past where a referee sexually harassed or inappropriately touched a student. Those are in my brain, so I can't unknow that.
Yep, true.
And if we receive all documentation from each employer prior to the end of the 20 days, can they begin working? I think, yeah, at that point, you've completed the process. You can start. I mean, as we said, arguably maybe sooner, but that clearly, I think, would fall within that. Which leads us to our last question, and I think it's a good one to end on. And I think it helps us reflect on this process and its intent a little bit. Is there a way to actively engage a candidate for employment in this EHR process beyond merely executing the consent for release as a condition of employment? And I think the answer to that in terms of a technical answer is plainly yes, because the statute permits us to have additional background check requirements beyond the minimum here in the statute. And so I think that we can create a process to do that. And so that does raise other questions, because while the answer is yes, it's yes with strings, right? Because we have to be careful about things that start to get into protected classes. And I think if it's done appropriately, and if it's done judiciously, and if we know where those boundaries are, I think that is not only possible, but could be very helpful in helping a candidate for employment navigate this process. There are some landmines to avoid, right? Asking about protected classes, making sure we're giving a fair process, making sure we're still minimally complying with that process. But, I think that there is a way here to, if an employee or a potential employee is going to have a problem in this process, to let them know this is something you're going to have to do. And I think David talked about that a little bit earlier about how do we ask the question of all applicants without asking the question of all applicants, by alerting them to that requirement as part of the application process. I think that makes sense. David or Ellen, your thoughts on that?
Yeah, I think that the way you framed my answer was better than my actual answer on the spot. I think you're, alerting candidates to the nature of the requirements of the job. I mean, Brandon, this is something you and I have talked about endless times, even when we're doing our own hiring, is making sure that people understand the nature of the job and the requirements for the job. And I think this becomes part of that discussion as well, is, there is this employment history review requirement, and we want to make sure that you're going to be able to comply with that.
Yeah. One more question that popped up here, and then we can have our closing thoughts here to round things out. If a person volunteered at another place working with children, like a church camp or something like that, should those be listed as an employer? Well, in part, I think that our responsibilities related to that are going to depend upon what the applicant does, because we may not know about them unless they disclose them to us. Unlike other school employers that we would check in Ellis or whatever, right? We wouldn't know that without, without their disclosure. So if they are disclosing them like an employer, then I think we follow the process for them. If they don't disclose them, we frankly may not know about them.
And I think we want to resist giving advice to employees about what constitutes an employer. I think the answer is, employer, anything that you think needs to be reported, and all employers must be reported. Fill the application out. We'll send out what we send out. I think that rather than answering the question for the employee, it's our duty where possible to make sure that they're transparent, that they provide us the information, and that we hunt down every employer that is listed on that form.
Well, another question popped up, so we're gonna answer it, and then I'll ask for your final thoughts. If we have a current employee that takes on an additional role like coaching, or maybe I would give another example, like being hired as the principal, like going to a different role, do we have to do the EHR?
That's that open-ended transfer question that we really don't have a solid answer on. I think the answer is a continuum of risk calculus. The statute explicitly refers to reassignment within subcontractors, and also explicitly refers to other types of assignments, but doesn't necessarily, and refers to the requirement, the absence of requirement if it's a transfer and the EHR has already been done, but then is silent on a transfer where an EHR wasn't done. So no, we don't have to do a new EHR where it's already been done. That's clear in the statute. But if we haven't done one, it's a continuum of risk question. How risky do you feel it is to move that person to a new role without conducting an EHR? And do you want to minimize risk, or are you comfortable with the risk where you are?
All right, I'm going to turn to each of you for final thoughts, and then I have a couple thoughts to share before we end. Ellen, any final thoughts from you on this as we navigate this with school districts?
I think my final thought would be meet your obligations under faith law, but don't forget about your obligations under other related laws.
Yeah, I think that's an excellent point. These are not happening in a vacuum, and there's clear connection, even by the statutory language themselves, between Title IX, ANCRA, other responsibilities that might exist. I think that's great. David?
Two things. First, we'll post the PowerPoint to the website additionally. I know that we sent that out with a Dropbox link. We'll at least make sure that it is findable somehow, because I noticed that we continue to have some people who are struggling with the chat, and I wanted to make sure that people will either send it out by Dropbox to those registered, or we'll make sure we get it on the website. But regardless, we will make sure that you get a copy of the PowerPoint, because I think that's important. Second, and I want to make the general statement to my mind is that when I start teaching every semester, one of the first things I say to young administrators and teachers who want to be administrators is, you'll be shocked at how many groomers there are in schools. You'll be shocked at how many people have engaged in misconduct, and the cases simply have not allowed us the substantive proof to get them out. I think this is a read the room moment. It's a moment where we all have to recognize that at the end of the day, as frustrating as some of these requirements are, they're necessary. And there's some really good stuff happening here. And I think that to the extent we can comply with our procedural obligations in a way that substantively is helpful to getting more information and utilizing that information in a valid manner, in a defensible manner, I think we're going to end up with some really good case law that will help us in the future and may break some of those cycles that frustrate all of us when we get into having to remove some of these folks. So let's keep a mind to that as we work through these processes and try to give ourselves the best case possible going forward that we can all get behind, so that when we're at the Supreme Court, we can all say, this is why 852 school districts joined in this amicus brief to say this is why the law ought to be what it is.
I think that's great. I think that's right. Thank you, everybody, for joining us. I know this is a high interest topic, particularly given the number of people who joined us today. That says a lot to know where we are. And so I think what's really important for me in so many areas of the law, but this is one of them, is that when we understand why we're doing something, our compliance is always improved. If you just tell me I have to do something, if you say, Brandon, go out and walk around the building 3 times, maybe you'll get mere compliance out of me. But if you say, Brandon, go walk around the building 3 times because I lost my cat and I think they're around here somewhere. Well, now I know what I'm looking for and I can do that in a better way. And I want us to have that approach here. This statute is not the best written statute I have seen. And for attorneys, that drives us crazy because we can't just say, here's the black and white yes or no answer. And I know that's hard for you. But what I hope we can take away is that when we understand the reason why we're doing this, we'll get more than mere compliance. We'll engage this process with the spirit with which it was intended. And when we do that, it's going to be hard to get it wrong, you know? And I think that's the approach I want to take away as we all struggle together with this new burden that is upon us. That burden is there for a really important reason. And so I appreciate everybody spending your time together with us today. Appreciate all the good and thoughtful questions. And thank you, David and Ellen, for your time with us today. It means a lot. And we'll see you all next time.
Thank you, everyone.